Hi, Kuzangpo everybody. Welcome to our first Education and Migration Talk Show. My name is Jimmy Chiweda. I am a Client Service Officer here at Happiness Education and Migration Services. Today, I'm joined here with Mr. Ngawang Chiweda, our Registered Migration Agent here in Australia, and also a Licensed Immigration Advisor in New Zealand. So, the purpose of this talk show is to help make education and migration easier for you, as there is a lot of confusion around social media regarding visas, courses, and what pathways to take. We're here to help clear that confusion for you all. So, today's topic will be about student admissions and visas. So, moving on to the questions now. The first question is, when applying for a student visa, there's a certain requirement called the GSR, the Genuine Student Requirement. Could you please explain to us what that means?
Thank you, Jimmy. That's a very important question. And in technical terms, it is obviously called the Genuine Student Requirements, like the GSR, but most commonly, the word used for the same thing is the SOP. Many of us call it the SOP, which is basically the same. Now, what it exactly is it is expressing your intent, your genuine intent to study in Australia. And there are certain factors, for example, your current circumstances in your home country, the value of the course to the visa applicant, that is you. And then if you have been in Australia on a student visa, just as an example, if you want to study another course, they also look at, the value addition in terms of how you are completing a course, and then, you'll be taking up another course. So basically, to summarize, it is those factors that will assess your genuine intent to study in Australia and whether you're a genuine student or not. If you satisfy the GSR requirements, then you are pretty much like satisfying the Ministerial Direction 106, which basically, allows the Department of Home Affairs to make a positive decision on granting a visa to an applicant who satisfies the GSR requirement.
Okay. So, on the same topic, the GSR, and there's another term called the GTE, the General Temporary Entrant. Many people seem to get those two terms confused. So, could you tell me the difference, or are they the same?
I think that's a very good question because of the way it has been used, and both of them are used in their proper sense. What I'm trying to get at is that the Ministerial Direction 106 that came into effect in March last year, 2024. From that month last year, GSR replaced the GTE law. So basically, GTE was in effect until March last year, but it is no longer a matrix to assess the genuine intent of a student to study in Australia. Now, what's the big difference? GTE is genuine temporary entrant. So what that means is, before March last year, you need to show to the Department of Home Affairs that you're coming to Australia with a genuine intent to study, and then you're a temporary entrant law, GTE. The name itself is very clear. You're going to come here, study, be on a temporary visa, and go back to your country law. And then, work on your career, get into a better paying job, and so on. Now, from March last year, the focus is on genuine student requirements only. So there is no hard and binding rule that you need to go back to your country. Now, when I say there's no hard and binding rule for you to go back to your country, well, if you have better opportunities in your country, like after you finish your course, that is fine. You can mention in your GSR statement. But earlier, GTE required you to go back to your country. You're a temporary entrant. GSR doesn't have that requirement. Meaning that, say you are studying nursing, for example, you could potentially mention in your GSR that nursing is a good PR related course. If you get a PR opportunity, you want to avail PR through those general skill migration visas and other potential visas. So department is borderless whether you're going back to your country or not. Before, yes, GTE, they wanted you to go back, but GSR doesn't have that requirement. So that is the difference which people need to understand, especially when writing your GSR statements. I've seen a lot of GSR statements mention, I will do this job, I will do this course here. Once I finish, I'll go back to my country, I'll have a better paying job. Well, you can write that. I'm not saying don't write that. But as per the ministerial direction 106, again going back to that reference because it's a policy document, there is no compelling need to mention that you have to go back to country. The department is more concerned on whether you're a genuine student or not.
Okay. I'm sure a lot of people, it's a lot of knowledge to take in, but I'm sure everyone will understand it in their own times. Now, moving on to another aspect of processing the student visa, there is a financial aspect to show, the financial evidence. So for that term, what kind of evidence do you need to show and how much do you need to show?
So on the financial side of things, see, the department is very clear. I don't know if people have heard about that streamlined, evidence requirements thing. Well, some people might have heard in an indirect way because people talk about the country level and the education provider level. So basically, the department does their assessment on a on a routine basis, which is like once every quarter or once every 6 months. I'm not very sure on that, but they do that 2 or 3 times a year. They come out with the assessment level of the education providers and the country. So at the moment, Bhutan is at level 2 lah. So basically, on a scale of 1 to 3, 3 na bachin, it's more like you are at the lower assessment thing, which is like not a good place to be lah. 1 is the perfect place to be. So Bhutan is in the middle too. Now, as per that streamlined evidence requirements, that matrix, if somebody is studying in say Queensland University of Technology, so basically QET is at level 1. So country level 2, education provider level 1, basically you are subjected to streamlined evidence requirements. So as part of this requirement, there's no need to show financials. There's no need to show your English proficiency level. So you can afford not to show a financial. Now, when I say not to show financial, people will get again confused. People in Bhutan will say, well, everybody asks us to show this show money. That loosely used word is show money. We have to show money, and then that's a requirement. That's why we are taking up education loans and all. But if you really go by the policy, there's no requirement law, provided you fulfill that streamlined evidence requirements. But say if you're studying in a college, say a college that is at level 3 and Bhutan is at level 2, so you fall in the lower matrix. In that sense, if you fall in that lower matrix, you have to show financials. You have to. There's no way you can avoid not to show it. And you have to show English proficiency. That being said, now people often ask, well, even the colleges ask us to show the financials, even the colleges ask us to show the English proficiency level. Those are not visa requirements law. Those are the requirements of the education provider. They want to satisfy themselves that to any student financials, okay, he has enough money to pay his tuition fees. He has the English proficiency scores that he can do that course. Those are education provider requirements. Visa ki mila. So that's where the distinction is. And then there is also a policy element, the Department of Home Affairs Kinalu, that even if, for example, you are studying at QET, even if the streamlined evidence requirement says you don't need to show financials, you don't need to show the English proficiency, the department, the case officer, when your visa application reaches them, they have categorically mentioned that they may ask for financial evidence if they feel that they want to look closer at your application. So that's why what I normally tell my potential clients and my clients who have onboarded is that while you don't have to show these things, but it is always good to get the documents ready lah, because later on, if the department asks for it, you have to be well prepared. You just can't run around and arrange finance and so on. So that's how the whole system has been structured lah, in terms of what you need to show, what you don't need to show.
Okay, so thank you for that. So now, let's say a client has successfully gotten their GSR outcome it's been approved, they've met their financials, they've got their visas granted, and now they're here in Australia, studying a course, for example, let's say a master's business. But then, for some reason, they would like to change their course now. Are they allowed to do so?
Well, technically speaking, the change of education providers, the change of courses is something that should not happen, but it's happening. There's no hiding these things. Well, we have had experiences of students who came through our consultancies, and other consultancies have similar experiences where students come here and in the process they change providers, they change courses. See, it is doable, but it is doable at a certain stage. As per the requirements in place, you need to finish at least 6 months of your principal course. Now, when I say principal course, if you're on a package course like diploma leading to degree, 6 months of degree course is your principal course. So you have to finish your diploma, then you have to finish your 6 months of degree course, and then you can make that switch over. You can change your education provider. But I have also seen that there are students who are finishing their diploma and not finishing that 6 months of principal course and just moving on to a college. I wouldn't want to name that college. And it's happening, but the students probably don't realize this could result in an issue upfront, but these issues might come up later when they apply for another visa, whether it's student visa or other related visas, because the history will always build up. So now, going back to your question, if somebody comes here and wants to do another course, see, there are risks involved. Now, we talked about the GSR earlier. Now, your genuine intent to study at, say, QUT or, say, for that matter, Master of Business. Now, you're saying, oh, I want to do business because it gives me that opportunities. Later on, I want to open a business, or I want to, work as a business analyst or business related, profession. And you like sort of really expressed your genuine intent to study business at QUT. QUT, obviously, for the reasons QUT is a, good education provider, and you want to like learn from good professors, good lecturers, etc., etc. And then now you're moving on to another education provider just to save some tuition fees, and then you're even changing courses. Some are doing some are changing their courses. They came here on business and now they are on a different course like early childhood education or nursing or something else. Now what this can lead to is, next time when you apply for another student visa, people call it student visa extension. There's nothing called an extension. It's a very loosely used word in the context of visa applications. So basically, in such a case, you're studying at QET, you did your Masters of Business, say 6 months, and then you changed to a non-university level education provider and you started learning Master of Nursing, for example. So you already lost 6 months, your visa period is not enough, so you need that 6 months or whatever later visa to finish your studies, the course that you change into. At that time, when your application goes to the Department of Home Affairs, then the whole history comes up front. How you came here to study something, how you change your education provider. So all these histories will be seen and refusals are happening. So, see, when I say refusals are happening, some people are getting grants also. So it's a mix of refusals and grants. And some people say, my friend did that change, he got his visa, and my visa got refused. So see, it doesn't work in the way you want it to work. Now, the way things have worked out for your friend may not work out for you. So it's always advisable to not even change your education provider and course in the first place. But if you have to change, you really need compelling reasons as to why you changed, and the risks are quite high.
So I'm assuming those are the main reasons that cause student refusals.
Yes.
Okay. So let's say now, for example, let's say a client has got their student visa refused. can they apply again? Is there a certain cool time, or like what would they have to do? What is the procedure for them to reapply?
So see, now if we take the same example, like somebody who hopped onto a Masters of Nursing and needed some extra time and they applied for a visa, see the visa got refused. It can happen and it may not happen also. But if it happens, now that person who has submitted that visa application is on a bridging visa, because what normally happens is when your visa is about to finish, you apply for the next visa to finish that studies, and then you're on a bridging visa A and your visa has been refused. So then you have two options left. You either pack your bags and go back to Bhutan, leave your studies midway, or you make a merits review appeal to the Administrative Review Tribunal. Now, not getting into too many details, the tribunal is a body which will assess your case, because you are, submitting a merits review application indicating that you're not happy with the decision of the department. Your visa should not have been refused based on your own justifications, while department have their own justifications that you're not a genuine student, you're just hopping from one course to another, changing education providers. So they have a lot of reasons, and those refusal reasons are highlighted in the refusal letter. So tribunal will do an independent assessment. Now, when the tribunal does that assessment, you will continue to study and you will continue to have the same benefits. For example, if you're a student, get to work limited number of hours during the study period, and once it's like vacation and all, you can do like unrestricted work. Unrestricted work in the sense that you can work as many hours as you can. So that sort of arrangements are in place for people whose visas get refused.
Okay. So how would you know if a person is, let's say, how would you know if they qualify for the appeal? How would you know if they're allowed to?
So if you're onshore, by virtue of the legislation in place, you are allowed to appeal. So anyone who is on onshore, if your visa is refused, whether it was refused for the right reason or the wrong reasons or some errors by the department, which happens at times. Department makes mistakes on visa like decisions. But in such a case, it is not the mistake of the department. Department felt that he or she did not meet the genuine student requirements, the GSR, so they refused the visa. So in such a situation, what can potentially happen is the same thing like submitting a merits review to the tribunal. And if you're onshore, everybody gets that merits review rights. But if you're offshore, there are certain cases where you can get merits review rights, but majority of people who apply from offshore, they never have the merits review rights.
Okay. So that was the final question. Thank you so much for your time today, and hope we were able to clear some of your doubts and worries. And if we were not able to get to your questions or have any questions in mind, please leave them down in the comment below. And also, if you guys have any topics you guys would like us to talk about for our next episode, please drop them down below as well. Thank you. Make sure you like, subscribe, and turn the notification on for some more. Thank you.
Thank you.